Hello, my name's Dawn Rodger. I'm the in-house solicitor for the Musicians Union, and I'm here today with Tim Northrop from NMD Solicitors. Tim's here to talk to us about the importance of partnership agreements and how the MU can help you through our partnership advice service. Hi,
Hello,
Tim.
Dawn. Hello, everybody. Good to be here.
Thanks for coming.
So, my background, I suppose, we should start there. I've been a solicitor in the music business for roughly 35 years. During that time, a lot of my work has concerned partnerships between members of groups. It's in one sense, very simple, another sense, very complicated subject, because a lot of groups don't know they are actually in partnerships. Often they think it is a choice as to whether to form a partnership. The reality is, without either intending or planning it, if you start performing together as a group with a view to profit, you are in fact in a partnership. This is governed by an old piece of legislation called the Partnership Act 1890. It's obviously, due to its age, drafted a long time before musical groups came into existence. And it is, whilst a good piece of legislation, it in many ways doesn't cater for the needs of contemporary music groups. And the key point of it is that as soon as you work with other people in a business with a common view to profit, you are in fact, whether you know it or not, in a partnership and governed by the Partnership Act 1890.
Tim, is that even if you haven't got a written agreement?
Absolutely. A written agreement is what we're really here to promote today, and I think that's the essential point to take from this. But the Partnership Act will govern your relationships, whether you like it or not. And it is, as I say, generally a fairly good piece of legislation. It's quite a short act. It's not terribly difficult to read, but it does work as a sort of catch-all solution to people working together. And so whilst it provides a framework for that relationship, it certainly doesn't always suit the particular requirements of a group. So, as I say, as soon as you start performing with others as a group, all the fun begins. It's great. You get a name, you start playing some gigs or doing some demos, recordings, whatever. If you're doing so with a view to a business, i.e. making some money, selling some recordings, selling some songs, performing live, you are in a business. For this reason, it's known as the music business. And your activities are governed by the Partnership Act. Now, as I say, generally, that will work, but there are some things that may affect negatively the way you want as musicians to run your group. For instance, decisions have to be taken unanimously under the Partnership Act. Now, that all sounds great. You decide that you all want to decide all your decisions unanimously, but sometimes it would be best if you had provision to decide these by a majority, be it a 51% majority or a 75% majority. It enables you to tune your relationship to the way you want to work, and you can specify that certain things, for instance, signing a recording contract, you want unanimous agreement. It's a very important thing. For other things, such as appointing an accountant, you may say, well, okay, we can do that on a majority decision. Some decisions are more important than others. Repertoire. You could say repertoire has to be decided unanimously, or you could say, well, it's one of those decisions we don't really need to fall out about too much. So if the majority want to go with that. And so you find, that's a good example. Decision-making is a useful way of catering agreement to suit your own particular needs. Another thing about the Partnership Act is that it provides that all members share assets and profits equally. And again, this sounds like a great idea and very friendly, and everyone gets on and we're all in it together. However, from a practical point of view, if a band starts up and one member, for whatever reason, decides they're going to pay for the first recording session, they've obviously put a lot of money into the group. And if the group splits up shortly after, do they really want those assets spread equally between all members? You may go, well, that's perfectly fair and that's what we're in for. On the other hand, that may not be what you think.
Tends not to be what our members want. Most of them tend to say, that's my instrument. Or
Yeah, well, again, that's another point, instrument. So, a vocalist generally comes along with a microphone, whereas a drummer will have their kit, guitarists will have effects pedals and amplification and maybe more than one instrument. You need to decide how the ownership, or it's useful to decide how the ownership of assets of the group are to be apportioned. As I say, under the Act, they're just spread equally between the members of the group. So it's useful to be able to decide for yourselves how you want these sort of issues to be dealt with. Now, this doesn't mean you're sort of riding roughshod over the Partnership Act. The Partnership Act will still apply, but it will be tweaked where appropriate to deal with what you yourselves have agreed. So another issue that is common with groups is wanting to eject someone from the partnership.
We see a lot of inquiries about that.
Yeah, and I mean, it may be for reasons of the complete hostility. It may just be one of those things where somebody wants to leave, and it's all terribly amicable. That is covered by the Partnership Act. The problem is it's a rather drastic measure. If one partner leaves, that terminates the partnership. And that's it. Under the Act, you are supposed to then dissolve the assets of the partnership and split them equally between the members. That's a problem if, it's a four-piece group, one member leaves, the other three want to carry on. They don't necessarily want the assets dissipated.
They tend to just want to know how to fairly buy one member out. Or
Yes, and that's what a written agreement can provide you with, is that framework to allow an orderly transfer, and ideally to engineer it so it isn't a termination of the partnership, but is a retiral from the partnership, so that the existing group can, or the remnant of the existing group can carry on with the existing contracts. Because if the partnership is terminated by one member leaving, then technically all your agreements with your record company, your manager, your publishing company, and any live bookings you've got, they terminate also. So you've got to redo them. And this is a recipe for a lot of heartache and confusion and cost, frankly. So it's, that's an unfortunate sort of side effect. It also means that under the Partnership Act, if you want to get rid of a member, it has to be a unanimous decision, and that includes the member who is being thrown out. And obviously they may not want to be thrown out. So, that leads you inevitably to a dissolution of the partnership, a dissolution of the group. Who owns the name at this point? You can't just split the name 4 ways or 5 ways or however many it is. It can often lead to a situation where none of the members can use the group name, which is, a tragedy if the group is gaining traction under that name. So that's clearly a problem. The Partnership Act also provides that any profits you make from the activities covered by the venture belong to the partnership. Now, that's perfectly sensible, but in musical groups, often you'll have members who want to do a solo side project, maybe do some production work, some DJing, certain things like that. And technically that money belongs to the partnership because you're doing things which are covered by the ambit of the partnership itself, what the band does. So again, that can provide problems with and resentment. So there are certain tweaks that can be done. Now, as I say, it's perfectly possible and certainly advisable to make provision to sort of alter the terms of the Partnership Act as it applies to the group. You can do that orally. If you sit down and have an agreement with your members or your fellow members as to what you're going to do, how you're going to split the assets of the group, what's going to happen to the group name if a member leaves or the group split up. Particularly with the name, it may be that one member came with the name, it's their name, the rest are joining in and happy to share in the profits. But actually, the one who came up with it says at the end of the day, if we all split up, I want to carry on using that name, and the other members may go, yeah, that's fine, or may not.
I guess the trouble is when you break up several years down the line or you're in dispute, people remember things differently, don't they?
Absolutely. This is a problem. One of the key fundamentals of law is that an oral agreement is entirely as enforceable as a written agreement. Well, that all sounds great. The trouble is it's like witnesses to an accident. Everybody has a different view for good reasons or bad as to what they remember about what was agreed and what may have, you may have thought you agreed something in the pub and then a couple of days later, a couple of people are having a chat and they, oh no, we'll change it just to make it a bit different this way. But another member wasn't there at the time and, So whilst an oral agreement, perfectly fine, perfectly legal and enforceable, it carries with it its own problems. So a written agreement is absolutely key to giving the group certainty as to how the group is to be run, how assets are to be shared. You can say, well, look, I joined the group with a lovely, great Marshall stack. If we split up, I want to take that with me. Yeah, fine. Or I came with some previous songs that I'd written. I want it agreed that those songs are definitely mine, whatever happens. And then you can decide how decisions are to be made. As I say, decisions have to be made throughout a group's existence practically on a daily basis, some major, some more trivial. And it's useful to know how those decisions should be taken, whether everybody has to have a chance to vote, for instance, and then whether everyone has to be in total agreement or there's a number who have a majority view on these sort of decisions. And so we can set out what decisions we're going to make and how they're to be made. And then you can just point to that as a sort of ready reckoner for that.
Tim, when's a good time to enter into the agreement? Because I hear from members when I raise the pass service and they say, oh, we're just starting off, or we haven't got any deals yet, or we're just, gigging. It's best to get it sorted out at the outset anyway, isn't it? Even if you never do go on to
Absolutely.
make it big.
I mean, the beauty of the pass scheme is, yes, it isn't. It doesn't take half an hour to fill in the questionnaire, probably an hour. But but it does force the band members to look at these issues, fill in the form, and then I take care of the rest. And it's a free service, and this allows you to work out what's going to happen. Now, obviously, most bands do start off with fairly humble origins, just a view to the next gig. And then you find, well, it's going well, we'll do a few more. And then maybe a manager pops up or a record company pops up and says they're interested in the group. And it's very easy to get caught up in the excitement of it all and just think, let's just see where this runs. But at every stage, it's getting more and more complicated, and there are more rights being created, probably more assets being accumulated by the partnership. And every time that happens, there's a layer of complexity which should ideally be dealt with in an agreement. So, yeah, I mean, if you're just starting out and you're just going to play one gig at the local pub, as a lawyer, I'd say, well, have an agreement. Of course, that's what we lawyers do. I don't think the sky's going to fall in if you don't, but every time you perform more and more and songs are created, songs which may not actually then, the group may split up, but one member may take that song and years later exploit it successfully. It would be very good to know where the rights are in that. And even if you're just doing a few small gigs, it's often the case that one member will pay for the van to get you there, hire the equipment, and you can often get circumstances where recollections as to who paid what are somewhat confused or muddied. And so again, it's useful that you can set out how the money's to be dealt with. Any monies put in will be repaid before profits are split. So yes, the ideal time to do it is at the outset, but it's never too late in some sense until it is too late, until you do fall out. And then you're faced with trying to sort out who owns what, who can carry on with the name. And unfortunately, this is often where someone such as me come in and say, well, if you want to insist on your rights to your share of the proceeds of that agreement or a fair division of the assets of the group, including the name and the equipment, you may have to sue for it. And if you haven't got an agreement, that's quite difficult to enforce those rights, and also to come to for a judge to adjudicate on those rights. You know, they're only as good as the sort of information they get. And as I say, if you've got just snatched oral conversations between people as to what they may or may not have agreed at any regular point, a judge has got to do a very difficult calculation as to who they're going to believe and where they're going to find at the end of the day who's in whose favour. Whereas you've got a written agreement, and you know things go wrong as they do. If you take it, well, hopefully you should be able to look at it. We try and draft the agreements in a form that's user friendly. You can look at it and go, oh well, yeah, we're going to split up. This is what happens to the name. This is what happens to the equipment. This equipment was the guitarist before he joined the group, so, or she, that's their equipment. This equipment was bought with group funds. We've decided that we're going to split that equally between us. The name goes with so-and-so. It becomes much more straightforward. Yeah. So hopefully you may not need a lawyer to help sort it out. But if you do need lawyers, again, they can be useful, but can be expensive. A lawyer could hopefully look at that agreement and say, okay, well, it's pretty clear what we've got to do now, how we're going to split things up, and we'll just follow that process. It isn't, it has to be admitted, a guaranteed solution to all problems, because when bands split up, there is often rancor between the members and
a lot of emotion involved.
Exactly, and bitterness. But it, like a divorce, frankly. But if you've got a very clear guide as to many of the issues that relate to the group, such as the name, such as assets, physical assets, equipment, and so forth, but also things, more intangible assets, such as rights in recordings and publishing.
Yeah.
The ownership of recordings, under the law, it belongs to the persons who made the necessary arrangements for the recordings to take place. I mean, it's, again, not terribly helpful. Generally viewed to be the person who paid the money. Now, if there's one member making the payment, in theory, they own those recordings. Now, that may not be what the group want. Indeed, the member who
or
paid...
Or even realise.
Yeah, the member who paid at the time said, oh, no, it's by all of us. If you fall out, you may find a lawyer for the member who paid the recordings things. No, I don't think so. They're the first owner of copyright in this. So, it is useful to get these things sorted out at the outset. Similarly, publishing. A lot of groups like to share their publishing equally. No, come what may, everybody gets an equal share of publishing. Other groups, you have one songwriter. They insist on owning all the publishing. Well, it's good that you've established that at an early date. They may own all the publishing, but agree to share the income from that publishing. Mm-hmm. While you're in the group, you get your equal share of my income as the main songwriter. If you leave the group, of course, you don't get it anymore. And a lot of groups see that as a way to incentivize members to stay with the group, to be part of the whole, to make it a more cohesive unit, that the publishing income is split while you're a member of the group, but not when you're not. And, it's these sort of issues that come up time and again in the work that I do. And as I say, when you've got a written partnership agreement, it does tend to make life so much easier. It's, as I say, not a guaranteed completely cure-all for all problems. I mean, but it is yours to do what you want with. As I say, it starts with the completion of a standard questionnaire that we send out and for the members to sign. It's 6 pages long, and it necessarily does ask questions that may be a little uneasy for you to answer, but they are the questions that you do need to answer when looking at the nature of your relationship. It forces the members to think about how they want to deal with their relationship with each other, and how to deal with the success, and also how to deal with the things that go wrong.
Sounds a bit like a prenup for a band.
It is, and I didn't want to use that sort of terminology because, prenups do have a bit of a bad reputation, and it does point to an imbalance in power. Whereas this fulfills a similar function, but it is there not to sort of deny someone the spoils of the relationship, but to make sure everyone knows what their share is, and do it in a way which suits the members best. And there are so many ways to tackle the membership of a group. There are groups where you have 1 or 2 key members and then certain side members who maybe not part of the partnership themselves. We can cater for that, and so that everyone knows where they stand. The other thing is, groups do develop, and certainly I've come across cases where there's a dispute in a group. You ask the person who's consulted you, have you got a written agreement? Oh, yes. And you go, oh, fantastic, great. And it's written 40 years ago, and, when they were just starting out. Now, whilst I commend them for executing that agreement at the time, it is also a living relationship being in a band, and circumstances change. As success comes, the needs of the group change. So it is important to keep an eye on it, perhaps. It's a living document. You can change it change it every week if you like. It is as simple as that. Just to cater, for instance, simply adding a page at the back signed by you all which says, oh, we bought this equipment and this person put a bit more in so they can have a bit more of a share of it. And you can deal with it on a case-by-case basis.
Yes.
It may seem overly pernickety, but at the end of the day, 10 minutes just writing up a list and signing it.
It's evidence, isn't it, of what's been agreed.
Saves so much hassle later on when things, unfortunately, do rather inevitably go wrong, and they need to be sorted out. So, getting back to what I said at the beginning, whether you like it or not, once you do start performing with other people for a common business goal, you're in a partnership.
So you're in a partnership anyway, you might as well agree your own terms rather than have them inflicted on you.
Absolutely. Yeah. So it works the way you want it to work. It gives you the protection you need. And it may be that you fill in your questionnaire, you send it off to me or whoever, and we produce an agreement for you, and that's wonderful. And you never look at it again. That's fine. That really is not a problem. But you know that deep in a drawer somewhere or in a computer hard drive somewhere, it is there in case things do go wrong. And things going wrong can be very, very problematic. It's the best way to put it. My job largely is what's called a litigator. I either sue people or defend people, but it's all about going to court. When I tell people this, they say, oh, do you spend most of your week in court? If you do that, you're not really doing your job properly. Going to court is the last thing you want to do. What we're really doing is dispute resolution, finding a way to stop going to court, because unlike TV dramas, going to court is a horrendous experience for most people. I've met very few clients who've actively enjoyed it. Obviously, they only tend to enjoy it if they win. That's point one. You can lose, and that comes at a great cost. But it can take years for a case to get to court. Certainly 2 is run-of-the-mill these days. It can take longer if your defendant isn't cooperating or the claimant isn't pushing the claim forward as rapidly as they want to. And in all things legal, time is money. And it does rapidly become an extremely expensive situation. And as most people may be aware, in the English legal system, we have a concept of the loser pays. So it becomes almost like a game of poker where you're putting more money into the pot of legal fees, and it becomes then really expensive to get out. You think, I've got to win this case. I've got to get my money back out of this. I know I'm right. My lawyer tells me I'm right. Of course, the people on the other side have got lawyers telling them they're right, and this is the problem with the law. It isn't a simple tick box exercise. It is all very nuanced and down to ultimately the decision of a judge as to what they make of the evidence as applied through the law. So avoiding disputes is critical, and if a problem does occur, having a well-drafted agreement can go such a long way to helping you avoid the cost, the heartache of having to fight over it. And, you can get fights over the most ridiculous things because, as we sort of discussed earlier, it is quite an emotional relationship and there can be a lot of bitterness. And if there's a loophole where you think, I can annoy my former bandmates by arguing over something that really isn't important, I'm just going to do it for the purpose of causing trouble because they've upset me. Well, that can be a hugely time-consuming, bitter,
it's not
non-productive.
going to be something to litigate over it.
No.
We see a lot of upset because the band is still using a photograph on their website, for instance, with the band member who's no longer there, and that causes
again, that's a simple paragraph that upon a member leaving the group, they agree to take down photographs, references in any website, for instance, to that member. It's perfectly sensible. And also, conversely, you need to... Sorry, I've got rather lost in the point there. Sorry, I've forgotten what I was going to say about that.
Sorry, just on that moment there, Dawn, could you bring your microphone slightly closer to us?
Sorry, I moved.
Sorry, and obviously this isn't live. So
Yes,
the beauty of editing this all out.
How are we doing anyway?
Really well, I think. You clocked on 28 minutes, which, I don't know, maybe felt fast or slow.
It's gone
felt
quick.
About 10,
Yeah, it tends to happen that way. I can put a timer up on the...
No. I mean, let's just see how we get on. I've forgotten where we'd got to, though.
You were talking about removing images
from websites.
That was me threw that in, though, wasn't it?
Yeah.
Sorry.
Are you ready to go again, Dawn?
Yeah, I'm ready.
Okay, can we...
Yeah, all ready to go.
All ready to go. Do you want to ask the question again? About removing...
Oh. Can't remember how it came in. We see a lot of members who have left a band who come to us and are upset, perhaps, that their images are still on the band's website or being used for promotional purposes. Is that something that could be covered?
Absolutely. It is as simple as a little paragraph in the agreement which says upon a member leaving, whether via expulsion or voluntarily, any images will be removed and references in the band's biography can have to be amended. That's a bit of a pain when you're a huge group and you've got thousands of photographs, but, you can sort of deal there. You can't erase history, but you can say for promotion of the group going forward. So it's not like some sort of Stalinist purging of people's imagery from photographs, but it's for future promotion of the group. You don't have the former guitarist, bass player, drummer in there. And perfectly acceptable. I mean, frankly, if the replacement member comes in, they'd probably want to have their photographs in all the
Sure.
new material as well. So, yeah, absolutely a legitimate concern of a leaving member, and is something that can be very readily dealt with in the agreement to make sure that everybody knows what is to happen when a member leaves a group.
Great. It just seems, I can't see any reason why you wouldn't want a partnership agreement, Tim. If you're all MU members and you can get this done for free, filling in a
Absolutely.
questionnaire.
You know, as I say, it's a 6-page questionnaire. It does force you to think about things you perhaps haven't thought about, or you confront, how decisions are to be made or how members are to be removed. But they are decisions that are absolutely vital to be taken at the outset when you are still friends, when you are still getting on, because trying to resolve those issues once you've fallen out is very problematic.
Yep.
So it does mean you sitting down and putting some thought into it, but it can be a very useful, or is almost certainly a very useful exercise in working out what it is that you want from the group and how you want things to be dealt with. And it will help stop, just little nagging gripes building up over the fact that the guitarist has got a lovely shiny new Les Paul and, the keyboard player's still playing the old piano. You can deal with that and how that's to be dealt with in the group accounts and so on and so forth. It does help smooth those little things over. And if things do go wrong, we put in a paragraph that, first of all, you'll try the MU mediation scheme and see if that can help you. And that's, again, very useful. It gives you a clear route as to the first step, rather than thinking, what can I do? I'm going to drop the bomb, whatever. Because, as I've said before, the key is to try and resolve these things without falling out over them. It's a very negative and expensive business to fall out over silly little things, which unfortunately in this situation, to use the earlier analogy of a divorce, you do. It isn't just the big things, it's the little things that become totems of the wider problem. So, the agreement usually takes me a week or two to put together, and it isn't just here you go, sign it and have done with it. It's here you go, sit down, have a chat about it. If you don't understand anything, ring me up or send me an email. Or if you've got things you think, well, actually, we want to deal with that as well. I'm happy to, it's all part of the service. I can amend it to suit your needs entirely as to how you want it to be. And then, as I say, if you don't look at it again, that's fine. That's a good thing. You're getting on and there aren't any disputes. But if something does go wrong, then everybody is protected. And the idea is that it protects everybody equally. It isn't, as I said, there are often imbalances in the group, but if you address those at the outset and you know that one member is putting more money in or writing all the lyrics or doing all the press and promotion, that's another sort of bugbear I get quite a bit, that certain members say, well, I'm the one expected to get up at dawn to do the press interviews or the radio interviews and so forth. Again, we can address that and deal with that, and is that member reimbursed more for promotional activities and so forth. And if you don't think of that when you draw up your first agreement, it can be amended and, to suit the situation as it develops, because groups are quite organic. They do change the way the dynamics work and who's responsible for what. And, it's not something you want to be changing every month, but, every couple of years to look at it and see, well, should we really update the list of equipment and who owns what? Because, the group generates income, buys equipment. As I say, there can be huge disparities between various members, the value of their equipment. But if it's bought with group funds, then, that needs to be sort of dealt with and kept updated, and whether they can take that equipment with them when they go, or whether it's sold and the proceeds are split equally because it was paid for equally by the members. All these sort of issues, kind of unpleasant to have to go, well, I think I should have a share of the massive keyboard rig, but it's a fair question.
It's the time to do it, isn't it?
Yeah, it's a time to do it when you're at the beginning rather than when you've fallen out and you're paying some lawyer £450 an hour to try and sort this out for you. That's really quite negative.
Yeah.
So, and it isn't, as I've said, perfect. It doesn't mean that you'll never fall out with your bandmates. You will. And, but it does provide a framework and a reference point to helping. I'm sure at the union you get many people with questions about the operation of their band that come up. Are there some examples of those?
We see mainly the fallout.
Yeah.
When there are disputes.
Yes.
I think we've covered quite a lot of them today, Tim. A lot of the questions that come up about.
Yeah.
We had one recently which the members did have a partnership agreement, and they said we would like one person to leave. And I did say, is it covered? It should be covered in your partnership agreement. And they said, we just want to make sure we're doing it fairly and we're doing it kindly and ethically. So they just needed a bit of confidence and hand-holding to apply the agreement. But it was all there. They knew what to do. And,
as I say, it is supposed to be drafted in a user-friendly way. But, it's easy to say that as a lawyer. I can think, oh, God, that's incredibly simply drafted. But
we don't see many come back.
Well, that's good. That is good. And the idea, as I say, is that you can just sit down without a lawyer and read it. But if necessary, a quick bit of advice, is readily available on just what your rights and how to implement the agreement. It's much easier for an advisor, be it the union or a lawyer, to say, oh, well, you've got an agreement. It says this, this, and this. This is what you've got to do. This is how you've got to do it.
Yep.
As opposed to going, well, I better talk to all 5 members and work out what they think you agreed and when you agreed it and find out that none of them agreed. And that lawyer then can't advise because there's a conflict of evidence between the various members of the group.
Yeah, it would be the same answer whichever member asked us the question.
Yeah.
Great.
So I would say this, but I think it's a very straightforward and simple process. It may never be referred to again, but in the 10% of cases where bands have a falling out, it will almost certainly deal with most of those in a readily understandable, cheap and effective manner.
Yeah, for sure.
So, it's got to be a good thing to do.
I certainly think so.
Good.
Thank you, Tim.
Thank you, Dawn.